Arvind, shall we? I don't know whether he's here.
Yes, please start, please.
Yeah. Good morning, everybody. Thank you for joining on a Sunday morning. But I'm so sure that our speaker is so good and smart that he'll keep us all engaged for the coming 1 hour. Let me introduce you the speaker of the day for this session of the series. Senior Advocate P.H. Pandian is a name synonymous to corporate legal practice in Chennai. Actually, he's my go-to man for any corporate doubts I have. He was an additional Advocate General from 2012 to 2021. He's also one of the pioneers who had a proper structured training as a mediator from a recognized university. He's a trained mediator from the Harvard University, USA. And he's also a member of our, mediation committee of the Honorable Madras High Court. Today, let us understand from him how mediation can be imbibed into IBC practice, especially in the backdrop of so many sounds about it during the early part of the year regarding a committee being appointed, having our Justice T.K. Vishwanathan to, have a detailed report on this. He will have better knowledge and idea to share us where we stand as on date. Aravind, over to you.
Yeah, thank you, Mr. Shriram Shekhar. Thank you, Ms. Ambali Menon. It gives me immense pleasure to come back once more to speak on this very interesting combination of topics of IBC and mediation together. Mediation per se has had its own level of, I would say, interest in the last 20 years now, starting from 2005, 2006 effectively, and it's almost 2 decades. But we are yet to get a complete foothold as mediation in every sphere of life. But the relevance of corporate and commercial dispute, which are now getting very fast in terms of either resolution or the litigation coming to an end, mediation does play an important role. So far as Insolvency and Bankruptcy Code is concerned, I did want to give a little bit of background. Mediation, as we all know, we do have the facilitated the normal features of just go to the previous slide. Yeah. The facilitated and evaluated mediation, which we normally know. Now, which will play for each of this area of practice, I should say, changes from act to act or corporate commercial disputes per se. So far as IBC is concerned, just to give you a background of IBC compared to the US model, we are a creditor-driven regime. Only the creditors control this process. We call it as an interim process, meaning whatever action taken has to apply for everyone. It doesn't apply only for one individual. And it's to ensure that the company can be put back to feet is what is the concept, and not to typically kill the company. The IBC recognizes 2 categories of creditors, namely financial creditor and operational creditor. But in the Act, nowhere mediation exists, unlike Companies Act under 442, where there is a separate mediation provision given in the Companies Act itself. So the object of the IBC seems to be only to ensure that you have a faster mechanism to get the company to get its value maximized, and also to ensure it's a time-bound process and a revival process. That's a preamble of the Act. Now, while looking at it in this manner next, if you look at IBC, basically, I'll just run you through the 3 stages. There has to be a default by a corporate debtor. Now, corporate debtor is nothing but the actual borrower or the defaulter. The creditor institutes application to initiate the corporate insolvency resolution process against this company, which is a corporate debtor. We have 2 stages. One is a post-admission by the NCLT. NCLT hears the matter, decides that there is a default, decides that there is a debt, and it appoints a committee consisting of creditors or the CD. It takes charge of the management of the corporate debtor and appoints a RP to manage its daily affairs. These creditors remain in control of the CD till a plan is approved and through the COC. I'm not getting into the resolution professional, he's just an administrator. If the resolution fails, then you can resolve to go to liquidation stage of the same company. So if I may break to understand mediation, where all we can test whether mediation is capable of being involved. Now, before, after, during is the three words which you may see. But mediation itself for the purpose of IBC, in the experience of IBC for the last 8 years, IBC came into play sometime in December of 2016. Now we're almost 2024. If I may remember the manner in which IBC got introduced, I would only say lucky enough to get the first admission of the IBC case of a defaulter. It coincidentally was a government company of Kerala, which was put into insolvency on the first day, because the only thing we understood was issue a notice if it was operational debt 2 weeks later, 10 days later, and file the petition and get it admitted. There was no case law, there was no precedent. So the interpretation of law is 14 days time you should admit a petition. So now if you file a petition, it takes
I
minimum.
think you argued the section 10 also first time. Section
Yes.
10 at least for us, for our office.
Yeah. Luckily. So the context of understanding this law was so nascent and virgin that there was no case law at all. So evolution happened as time went over a period of 8 years. Now it is very easy to defend a petition, or even very tough, if you may say that, to get it admitted also. That's a financial creditor or operational creditor, starting from the application defects up to the hearing of whether there is a debt or default. So much of case law is developed. I always tell the amount of case law what insolvency and bankruptcy code has developed in the last 8 years, starting from December of 2016 till now 24. Half of those case laws, only Companies Act developed from 1956 to 2013. The amount of case law developed in almost 70 years have been developed in 7 years, twice the amount of insolvency and bankruptcy code. One of the reasons also was there were only 4 benches of CLB, Company Law Board, so the number of judgments coming out were also less. But the respective high courts were seized and then finally to Supreme Court. But insolvency code, you can see the NCLTs are seized with so many benches, so many cases on a day-to-day basis. And to be fair to the legislation, the reason it's got so much of litigation and case laws is only because it has had a little bit of an impact on the economic side. Therefore, the concept of whether mediation should be part of insolvency or not is a matter for debate. So at what stage can you consider this? Because as of now, if you ask me, the case law are basically you can't involve Mediation Act at all or mediation process at all in insolvency code. That seems to be the generally developed principle. But assuming for a moment we do bring in, because times always are in such a way that you evolve over matter of time. So because now even IBC has started getting delayed, plans are getting delayed, liquidations are getting delayed, recoveries are getting delayed. The admissions are also happening a bit faster, but not to the extent how it was. It has also, I think, now become necessary that you do have a resolution if possible, but you can't take away the purpose for which the insolvency code is there. Insolvency code is not a recovery mechanism. Insolvency code is not to ensure that your debt is paid back. No doubt a creditor-debtor relationship has to exist. So while doing that, the before admission in CRP stage in the first bullet is where you test the, I would say, the creditor-debtor relationship. After admission is now a debt and a default has been established. Company has been put into CIRP or corporate insolvency resolution process, and hence what happens is a time-bound manner thereafter. If that also fails without a plan, in liquidation, is there any scope? So in the first two, it has been tested to an extent a little bit, particularly the first one. But in the last one, in my view, at the moment, it's impossible to test it. But there are areas of, I would rather say, possibility of attempting a mediation also. So now taking the before admission into CARP process. So we all know that the management of the corporate creditor can engage in settlement talks directly with the creditor before he initiates the petition application. Sir, I can avoid. It's a typical normal pre-litigation process. Now IBC is also a litigation process. So if it's an operational creditor, you issue a notice under Section 8, and during the Section 8 petition, for the supplies or services given, you can discuss and engage in this particular mediation process basically, or a settlement process, if I may call. Mediation involves a third party, neutral, but a settlement process is bi-party also without involving any mediator at all in between. This can also be attempted at a hearing stage before the NCLT admits the petition and puts the company into CARP. And it can be done in the case of both financial and operational creditors. But after the order of this admission into CARP and the petition creditor working alone, it loses its significance to stop the CARP. Because after that, Section 12 capital A of the Insolvency Code takes over. There is a huge withdrawal process. So till admission, it's within the creditor's control. But after admission, unless before the COC is constituted or not, there are various gray areas there. We can go into that maybe when we have some question and answer session. So the dispute definition under Section 5, Clause 6. Now here, in this particular case law, the company is enclacked in a company appeal, somewhere referred to mediation also as included here. If you say dispute as defined under 5.6 is not to be restricted to the pending list or proceeding within the limited purview of suit or arbitration, and the term includes should be read as means and includes, including proceeding initiated or pending before consumer court, tribunal, labor court, or mediation conciliation also. So technically, it seems to have taken within its purview of dispute that if you have attempted a mediation, it meant that there was some litigation pending, and the litigation pending fell within the definition of a dispute under 5 clause 6. So therefore, can it be sent for an operational debt admission or not? The dispute stood in between in this particular case law. So whether mediation itself is a pre-existing dispute. Normally arbitration or litigation is a pre-existing dispute, or even emails, any document which will show that there is a pre-existing dispute. Under Section 12 capital A of the Commercial Courts Act, a pre-litigation mediation is mandatory for filing a suit before a civil court, and such applications of mediation are filed by the parties with the legal service authority of the concerned state. Now, very important is the Shubham Steel in the second bullet, where the mediation was instituted, commenced and pending at the time of demand notice sent by the operational creditor. So please note, a demand notice had already gone. The Honorable NCLT, after going through the mediation application submitted by the respondent before the concerned authority and notice of dispute sent by the CD, rejected the application of this OC under Section 9 Clause 5, that is saying that there is a dispute pending. It saw that there was a dispute pending. So you need to understand at what stage does a mediation culminate into a dispute. But in my view, a mediation itself would have generally been after the commencement of any kind of legal process. I won't use the word litigation process, legal process. Either a notice being issued. So the 12A itself will be something which you have already filed as a suit or as an arbitration process in the court, but before it is taken up, you go under 12 capital A. Therefore, technically, there is a dispute pending. So in all probability, if we go under 12 capital A and attempt a mediation, then that mediation can be a proof that it amounts to a dispute. That is what the NCLT Delhi says. Now, this can be taken from the principles of, this is one of the foremost judgments which you always keep using, Mobilox versus Kirisa software. Even now, it's very relevant. So there, if you see what the adjudicating authority, I'm just quoting and just reading it, to identify, and all this applies to only a operational debt, what I'm talking about. Because in financial debt, the question of dispute, the word doesn't even, it's only stopping with question of default. What the adjudicating authority needs to see is whether there is a plausible contention which requires further investigation and the dispute is not patently feeble legal argument or an assertion of fact unsupported by evidence. In terms of the view taken by the Honorable Supreme Court in the said judgment, this adjudicating authority need not satisfy itself that the defense of the respondent is likely to succeed. What this court needs to see is whether a dispute truly exists in fact and is not spurious, hypothetical, or illusory. What is important is that the existence of the dispute and or the suit or arbitration proceeding must be pre-existing, that is, must exist before the receipt of the demand notice or invoice, as the case may be. This is para 51 of Mobilox. So, very important are the words, if you see in the third line, in terms of the view taken, A need not satisfy itself that the defense is likely to succeed. You are not looking at the success of, which means you are not required to go into the merits of the dispute. But do you think there is no mala fide or it's a spurious or what we call as a moonshine when you are trying to raise a dispute? That is all what Mobilox tells to see. So when mediation was initiated before a demand notice is sent under Section 8, it was in a company appeal tested. That is, the mediation attempted prior to the Section 8 demand notice for all. So the OC initiated mediation under the Commercial Code Act under 12 capital A before sending the demand notice. Since the CD refused to participate in the mediation process, that is the respondent company against whom the NCLAT held that the corporate debtor was precluded from claiming that the mediation application and the subsequent commercial suit instituted by the OC tantamounted to a pre-existing dispute. So you will see at what stage is the mediation. See, IBC and mediation, I am breaking it into two. One is mediation itself possible in IBC. But when the mediation proceeding or mediation process will be treated as a dispute or not in the context of IBC. That is, second one is what we are seeing initially, but the larger principle of whether mediation process itself needs to be there will be down when I touch upon a little bit when the committee recommendations or whatever comes, a little bit. So in this particular case, now I will see from the different one from Delhi, the notice came later. And after finishing this, as usual, I'll just put it in the group, the presentation also. So when the ongoing pre-existing dispute in mediation was not genuine. So is the mediation happening? And while happening, is it a genuine process or not? So these were checks issued for supply of goods, dishonored, and the mediation proceeding is pending and going on before the center. Now, parallelly, the OC sends a notice under Section 8 and says that the CD has not paid the money, there is a default and there is a debt. Now, this, the Allahabad bench takes a different view and says, it rejects the argument of the corporate debtor and it admits. It says, the 138, I will not treat it as a proceeding because it's for a punishment, no doubt. And the mediation process also, even though it is a process for, I would say, reconciliation of the dispute, we will not do so. On the NCLT bench, Allahabad took a slightly different view and said, it is not a pre-existing dispute. It's not a genuine attempt by you. You took it to mediation, wanted to use mediation as a process to create a pre-existing dispute, and you're coming here. Therefore, we are saying that It will not be a ground for the pendency of the pre-existing dispute, and they admitted the petition. And if the pendency of, now we come to section 7, we saw section 8 and 9. Section 7 is for financial creditor. So if financial creditors involved typically in a DRT or some other place or a financial institution, housing loan, other things, if they are going to be involved in a mediation process, is it a bar? So the CD resisted the application under 7 on the ground that the mediation was pending. Now here, the dispute issue does not even hold good. For a financial creditor, all he has to do is there has to be a debt and default. It's sufficient. Dispute need not be proved. So the NCLT rejected the argument and said that the pendency of mediation is not a bar by saying one cannot accept the pending mediation process as a basis for rejecting the prayer for triggering the CRP in respect of the CD. There is no provision in the code which will create such a bar. Accordingly, aforesaid objection is rejected. I'm just slightly digressing in the context of this judgment by the Delhi bench. The reason is because we know the Mediation Act has a schedule of what all act it applies to. Consciously, the government did not add IBC because IBC from Supreme Court judgments time and again have been told they are a complete code by itself. Now, CPC had mediation as a process and Companies Act had mediation as a process and various other enactments also, including the Arbitration Act. If they had mediation as a process for the conciliation in some manner, IBC consciously did not have. So when IBC did not have, and it's a separate code in its own way, because if you see this act seems to have gotten a very elevated status, not because it's a very important act or very much higher in terms of, I would say, the practice per se in the last 6-7 years. It's because of its time-bound manner and ensuring that all the stakeholders get their resolution at the earliest point in time, simultaneously, if possible, to put the company back on rails or the project back on rails. That is why the government thought it fit not to include the code under the Mediation Act. Now, does it mean we have to not consider insolvency code vis-a-vis mediation per se? Now, that's a debatable point. Today, if you ask me, I will say mediation will really not be useful at this moment in an insolvency situation, because the purpose for which a creditor is coming, if it is found that it's a genuine case that the company is almost going down, and if we don't admit it, then the mediation process can delay it. But if the company goes in, and then there is a possibility of a mediation being attempted parallel to the timelines granted, because you're not yet come to the second part, well, that's a debatable issue. The first part, I will say, it's, in my personal view, not debatable, but the second part, it could be debatable. When you come to that, maybe we can see. So that's what the committee considered. When second part comes, maybe I'll just mention that. So whether the NCLT can refer application under 7 for mediation under 442. I was lucky enough to argue this matter before NCLAT. NCLT had referred it to mediation. It said, look, you both are two entities fighting only for money. I'm invoking the powers under section 442 of the Companies Act and referred it to mediation. Pardon me, I had to argue that mediation cannot be used under IBC. And in this White Stock appeal, the NCLAT held that what the adjudicating authority or NCLT is required to is only to decide whether there is a debt and default. They were not required to look at any other alternate remedy, and therefore NCLAT said you can't consider this and set aside the NCLT order, and this gets confirmed also in Supreme Court. So that's the legal process as of now. Because on a logical mind, you will think when two parties are fighting, why can't we mediate? But what are the parties fighting for? If you see, they're not fighting here. The person is saying this company has become insolvent, put the company into insolvency. He's not asking repay me the money. If he's asking repay me the money, then there is a recovery mechanism or some kind of result remedy for him. He's not getting a remedy here. He may get the remedy only when the company gets revived or a resolution process is sanctioned. So, if you see what they say further, not in the same judgment but subsequently, can they refer under section 9 for mediation also using 442? We saw section 7. They follow the same principle. So far as here it's concerned, its operational criteria is there is an arbitration clause. But so moto they referred it to mediation under 442. So the NCLAT Delhi bench said the AA was concerned with the insolvency resolution qua the operational debt which the CD owed to the OC. It was immaterial whether it was solvent or insolvent qua other creditors. The INB code would not permit the AA to make a roving inquiry into the aspect of solvency or insolvency of CD except to the extent of the financial or operational creditors who sought triggering the CARP. So, in effect, closing that, you can't send it to mediation. There's one more NCLAT judgment in the Codex of India Services versus Chemisol additive. Now, can the NCLT or NCLAT compel parties to settle disputes through negotiation? Now, negotiation in this context, I would like to put also involve the word called mediation because this is a Supreme Court judgment. When it went detailed into when parties can they attempt settlement, it's a very important paragraph to understand because at the moment, this is what is staring at us from Supreme Court. On a bare reading of the provision, it is clear that both clause A and B of section 5 of 7. Now, 751 is in regard to a financial creditor initiating a CARP process petition under section 6. In clause A of 5, the A may by order admit the application or in B, it may by order reject. Please note, thus, two courses of action are available to the A in a petition under 7. The A must either admit under section 5 or it must reject the application under subsection 5. The statute does not provide for the A to undertake any other action but for the two choices available. This is what the E.S. Krishnamurthy case says. So, in fact, today, because it's ruling the ground at the moment, the A are not sending any party to mediation per se. Rather, they give, in a practical sense, adjournments so that parties discuss and come back, but not a formal reference to mediation. So, what do you do when you receive demand notice under 8 during the mediation process? When the mediation process is going on, if you receive a notice. This also was considered by the NCLAT principal bench. You respond to the demand notice with the notice of dispute, demonstrating the fact that the dispute is genuine and the mediation proceeding is already ongoing with respect to the same. Now, this mediation process, as I told you, should be through some regular, proper process under a mediation center. What you do as two parties negotiating also, the mails or the letters can separately show. That we can discuss separately. That is to show whether there is a pre-existing dispute or not. So, what does a NCLAT say? Responding with a notice is not mandatory but preferable. However, not responding with a notice of dispute is not fatal. Now, that principle is what I've extracted. Suppose during the mediation process, just because you don't respond to the notice, it's not just during mediation process, but also otherwise. I issue a section 8 notice, the response doesn't come, I've gone and filed an NCLT petition. Does it mean that amounts to admission? No. That's what the Delhi High Court, Delhi NCLAT says. No. Even if you are not issued a reply, you can still show that there are pre-existing disputes. So, the same principle applies even during a mediation process. If you have not responded, but the mediation is still going on, you can show A, that the mediation process itself amounts to a dispute process if you're able to show it how it was already filed as a suit or under 12A or under civil suit, under normal civil code where the plaint has been presented but the court has sent you under 89 or in some manner even before numbering. Then you can say that my non-issuance of a reply notice, I had waited, you can't hold it against me in the context of mediation. So that brings us to the second part. So here I would like to touch, because after admission, the role of that creditor goes away. Whoever initiated it. Now comes the COC, the RP, various other things. So when the committee wanted to consider whether we should include mediation as part of the IBC process, they thought over it and have still thought that it is not advisable at the moment to consider, I would say, mediation as part of the code presently. This 12 capital A process is something which we know, where you can withdraw and walk out. So who are all the technical persons who may be involved in that process? The RPs, he's a neutral party, technically he can be involved. Then who are all suited to facilitative, evaluative, or trying to do so to ensure that the withdrawal happens? Yes. So when the committee gave its recommendations, one of the important recommendation was, please bring the mediation framework under the code itself, because the IBC itself is a self-contained code. Bring an independent infrastructure to ensure that the objects of the code are met. Most important is, because the code is an interim process, there are various aspects of public interest get involved at various stages, and hence we should not include this through an amendment to the 23 Act, the Mediation Act, or a notification and entry 13 of the first schedule to the 23 Act. So the committee recommended, in fact, to introduce voluntary mediation as a dispute resolution mechanism without affecting the timelines for various insolvency process as of now. So how can we run parallelly seems to be their thought process. So some of the core manner in which they've said, I have not put it in the slide because it's still in a very, very, very embryonic stage. They say that you must ensure that the central government and the IBBI have powers to make rules under the code for mediation. So in effect, what they're trying to say is, bring the mediation under the IBC itself. Don't include it with any other act. That seems to be the thought process. Yeah, next. Now, I just put this across because the committee recommendation says that it must be the NCLT who should appoint the neutral party. At the moment, because of section 442, various NCLT benches have mediators as a panel for Companies Act matters. And more or less, it's the retired High Court judges who are generally appointed, but not mediators per se, sitting under Mediation Act or under the mediation rules. So at the moment, how to initiate the mediation is still not there in the Act, but preferable with the informed consent is what the committee says. Then the RPs, if they appointed, will they do an evaluative process? RPs are sometimes not neutral parties because they're usually appointed by the creditor who's applying. So therefore, there's an element of no neutrality there. The name is recommended. I mean, he may claim independence. Very rarely we see that. So the RP should move parties towards a different perception of their own situation for each other. I would recommend for the beginning, none of them who are part of the IBBI empaneled RPs should be there in the empaneled mediators at all.
I agree.
It is better that they completely are out, because there'll be a conflict of roles. He's already required to do a complete process till he takes it through to a plan or liquidation. Parallelly, he can't run a mediation. Anyway, they are running negotiation process, because the creditor who got the petition admitted will use RP only to negotiate with the company. More or less 9 out of 10 times, that's what is happening. Or if it is not so, he wants to hold on to the position. With no offense meant anyone, it is just that it's happening practically. So the committee has also referred post institution, but pre-commencement you can consider, but it must be done with express intimation to NCLT, subject to a mandate that it should complete within 30 days. That seems to be an intention, but I would rather say that you are virtually helping the company try to arrange its affairs in 30 days time, because we always don't look at the positive side, we always look at the negative side and try to rearrange our affairs. So how far that's going to be go. And post amendment, post admission, which is the part we are seeing, they say 66% of majority of COC, if they are able to consider, you can send it to a mediation network apart from 12 capital A, because 12 capital A we know is 90%. But if a mediation is Sweden, can we consider reference to with 66%, which is equal to the plan effect, seems to be a suggestion made. So subject to that, other things are all running. We have no clear view. So withdrawal from CRP in the pre-section 12A IBC era 1. So these are judgments of brilliant alloys and other judgments, because there was no section 12 capital A at all in the code. So when a company has been put into CRP, how do you withdraw? There was no process. So under 142, because I had done this in NCLT here in Chennai, and we did not even go to NCLAT, straight away they went to Supreme Court. And Supreme Court said, when two parties are willing to settle, no doubt the court never envisaged. So let's permit them to withdraw. And in brilliant alloys, Supreme Court said, we are invoking 142, Article 142, but recommended to the government, please find ways of also bringing a process for withdrawal. That is how 12 capital A came into the IBC. Now, post 12 capital A, but pre-section 12 capital A, again, the second judgment which I would like to place is in regard to one more. Again, they took 142, but please see the last two lines. The relevance rule be amended by the competent authority so as to include such inherent parts. This will obviate unnecessary appeals being filed before this court. On the facts, we also take on record the settlement. Now, from 2017 till effectively, if you find 12 capital A was not there at all, so every time we had to go to Supreme Court. So number of IBC cases which got withdrawn under 12 capital A. You can see the admission is 7058. Withdrawal is almost, if you see, 15 to 16%. Or 19% have been withdrawn, where largely they just agreed for the... So putting together 16% cases which had successful plans and 19% where CDs agreed for settlement, it can be said that 35% of cases saw positive impact on IBC. That's 1 in 3 cases. Now, mind you, this is without even mediation. This is based on only the regulatory framework. This as late as till last year. The numbers we don't have as of now, but I'm just placing how the numbers speak, admitted, the closure ongoing. So effectively the green is what is lower, if you see. So the admission is high. The withdrawal is also high, if you can see. So that is going up. You just see the proportion. Forget March 20 because that's when 12A came. But after that, if you see the numbers, from 21 onwards, the bars are, as they're growing bigger, the withdrawal bars are also growing bigger. That shows that the act is giving relief. But assuming for a moment, if we have mediation in some model here, will the blue come down? Is what we need to see. Because the blue comes down, automatically the yellow also will come down. And maybe the green also will be very much down because the pendency won't be there. So the attempt is, how will you infuse, I won't use the word integrate. Mediation can never be integrated in insolvency, or insolvency can never be integrated with any other law. But in the insolvency process, how will you infuse in some place, or introduce, I should say, in some place, the concept of mediation? Sometimes what happens is we settle, whether with or without mediation, in some manner, but there is a breach. How do you identify the debt and default? Whether CRP can be instituted again? Is there a debt and default? And is the default more than 1 crore? So after initiation, parties entered into an agreement. However, the CD failed to adhere to the settlement. Would it be at liberty before the AA was considered to seek revival? And they said, yes, you would be at liberty. But you have to also look at the terms of the compromise, if you have said so. So if you see here, again, in the second judgment, go to the next one. The MOU entered into under 9, however, the CD did not honor the MOU. NCLT erred in denying operational creditor further opportunities to approach NCLT while permitting withdrawal, and thus order passed by NCLT declining liberty to appellant to reapproach and revive the proceeding was set aside by NCLAT. So NCLT cannot say that you can't approach. So this is generally the practical side of it if you record a settlement. So what happens to a mediation settlement will be a different one. Now, will it be a judgment? Do we have to go back to... See, sometimes if you ask me very bluntly, it is actually advantageous for me to get a mediation agreement done here, because based on that agreement, I will say he can never come back to IBC. He has to go only to execute the mediation settlement as an in the insolvency execution proceedings or like a decree. But the word claim, it includes a judgment, whether reduced to a judgment or not. So whether a decree or not. So that will lead to a new concept of case law again. So something done for good can also have counterproductive situations also. So if a mediation agreement is not adhered to, what do? That also needs to be addressed here. Because in a civil law, it's advantageous because you got your right crystallized. Here, there is no right. So I take a typical case law. My colleague also saw a case and said, where let's say that you pay the money of enter into an agreement for 1 crore and I pay 20 lakhs and then I default. If I default and there is no clause for reviving the old debt, but say that outstanding debt alone I'll pay with interest. Now what happens? I paid off 20 lakhs. I've defaulted. It's come down to 80 lakhs. It is not yet crossed 1 crore. So he can't come back to NCLT at all. So the settlement agreements also needs to be drafted properly by the mediator or by the parties who do it without mediation in the present law. Because IBC is a very simple law, but with a lot of complications. So the simplicity of the act cannot rule out the future complications which come, as you are seeing, maybe in various suggestions and the case law which you are seeing here. So that's why you always put a liberty to revive the proceedings. So the CP was disposed of according terms. The terms provided a repayment schedule was incorporated, thereby making it an order and decree. And once this was a position, giving liberty to the FC to come back can be interpreted on no hypothesis other than the revival of the CARP. So this is a very important clause which you need to put in every case if you settle, whether with or without mediation. Tomorrow with mediation, can we bring them back to NCLT again? That should be the consideration. And in Himadri Food said so. Yeah, again, restoration, Krishna Garg also was never, if you see, this was even worse, where the settlement agreement was neither filed nor brought on record. The NCLAT refused to revive the CRP proceedings. So if you do an out-of-court settlement, that settlement cannot be used. So you should get it recorded. So each and every small different fact is affecting the settlement process also, which will apply to mediation is what I'm saying. So the rules are to be very careful. So the settlement agreement for withdrawing the IVC under 12 capital A. So normally 12 capital A is a case where you only record 90% voting and come out. But NCLTs have got into the process of looking into it as to whether it's a bona fide settlement or a fraudulent. Though in 2 or 3 judgments in Hutamaki, in Shiva Holdings. Shiva Holdings was dismissed in NCLT, dismissed in NCLAT, and Supreme Court allowed the withdrawal because NCLT and NCLAT said this settlement is against public interest. You are not even concerned. Supreme Court clearly said 90% with open eyes. If they approve, why should we look into it? They have withdrawn. They have applied the commercial sense of mind as much as like equivalent to a plan. So that being the case, you cannot go in unless there is a fraud or other things which the creditor should prove. So that being the case, the mandatory revival of the original proceeding instituted, if it fails, should it be brought under the Form FA? That is the consideration. So in a nutshell, if you may ask me, the settlement agreement should be an agreement mandatorily brought in writing and placed, and the Form FA, everything should be placed before the NCLT also, but NCLT cannot consider it and take a discretion there. So timeline for withdrawal under 12 capital, I've just put it for the purpose of law. Maybe when we have a short question answer session. When should I close so that I can take a few questions, or do I only answer the chat box?
I think it should be interactive. I myself have one, so if somebody else has got, they can ask
Okay,
because
then I'll finish off. How many minutes?
yeah,
I still have a few more slides to go. I'll just rush through. Maybe another 4-5 minutes, and I'll pass on
please.
the slides for future, so I can take at least 10 minutes of questions.
Thank you. Thank you.
So I'm not going into the rules. Then voting of withdrawal. This is the Beacon trusteeship. How to vote with regard to this? Maybe you can just see it later, just for the purpose of law. 12A we can skip. So in implementation of plan, that's the third part. The second part and the second part, I should say the subdivision of second part, because if the post-admission results in a plan, can modifications be discussed? Yes and no, both they say, because normally you are not supposed to amend a plan, but extension of timeline does not amount to modification of plan is what they say in NCLAT, this Ashok Datre. It's a very interesting judgment because normally you can't extend a plan. It's just all being given. Then is scope of mediation possible in liquidation? Yes, carry on. So withdrawal not permitted during liquidation. Law is now settled, in fact, by saying
Arvind, you don't have to speed up. I think it's very good. So you can please do it the way you thought. That's also good. Unless you're very
I
tired.
just have another 10 or 15 slides which I should finish in about 10 minutes or so. I thought that I don't want to eat into the
No, absolutely, because I mean it's very nice and it's too exhaustively done. So I'm very interested to know. I'm sure everybody would be.
Later I'll separately take a fee from you because I know that you want to see all this profession.
I know there are a lot of questions answered now. You're losing
So,
some money, Arvind.
on answering whether the withdrawal at Valley is permitted during liquidation, NCLAT Delhi in this judgment in 2024 says it cannot be because there were judgments for and against. The liquidation cannot be done. It's a very strange situation. We have you still can demarcate and say can a liquidation be admitted or not. So I'm going in the context of mediation. In this process, is mediation possible or not? If you ask me, it's not possible. In today's law, it's not possible to do a mediation in liquidation. But it is possible to do mediation during liquidation. Meaning, if the RP has to pay some money to someone, and the other party, like the banks or somebody, are disputing the quantum of adjudication of the debt or something, then it could be a mediation because it involves only numbers. It involves only crystallization of numbers, so you avoid any litigation. So there I do see when the various stakeholders who have filed their non-admission of claims, rejection of claims, those places can be considered even now for mediation, is a suggestion I'm making. So the guarantors also can be a concept where you can involve them in mediation so that to release them, they can negotiate. So you don't need a separate process to run through. So the bankers, stakeholders, wherever in a thumb rule, if I may say, it involves only crystallization of a money or a liability, you can attempt mediation. So if that is done, instead of filing a guarantor application, they come and say that so much money is payable. If you are willing to pay, yes. So the guarantors can also get released and go on with their lives. Yeah, then next one. No. So these are some of the findings which I have just tabulated for a conclusive portion. They say strong possibility of mediation settlement is possible. OC initiating CRP have demonstrated strong potential to settlement. See the third bullet, very important. Mediation Act 2023 is a one-size-fit-all legislation and hence not suitable for IBC. That's a committee's recommendation. Incorporation of mediation into Indian insolvency regime will require specific tailor-made mechanism to suit. Now, I've just tried to put across what the committee had framed as a flow chart that will cross it. These are normally the recommendations made that it has to be voluntarily done. Then the objective of the court should not be lost. Then it should run parallel to the mediation process. No provision should be included for stay or power to give it to NCLT until the mediation is over. Then automatic termination to ensure that the timelines are kept. That's why they suggested 30 days in some manner to an extent. Though these are some of the suggestions being made, maybe when you go through, somebody asked me whether the presentation will be given. Yes, I'll ensure that it's sent to the center and they can mail it to all of you. So the Singapore Convention also, I have compared it for the purpose of mediation. So this has been brought only to ensure that it must arise out of mediation defined under the convention, but not typically in the context of a insolvency context. It was more to ensure that mediation by the Singapore Convention. Just go to the next one. These are all to show what an enforceable agreements are. So in fact, in this one judgment, 94, broadly going back, what is commercial? The settlement cannot relate to transactions other than this thing. The settlement agreement must be international. All these are just brought out to show how a settlement agreement should be strong to ensure that you are able to hold on to it. All these are only explaining what the international, just cross it over. So this is somewhat a roadmap I've placed with a, in principle, I would say, my own observations are, it is too early for mediation to be part of IBC, but there are certain pockets of IBC where you can introduce the mediation process, for which the committee should work under the IBBI and bring it either under the code or in the rule making power and ensure that mediation is attempted, because I do feel now it is relevant, but without disturbing the overall setup. Now, last two lines, if I may say, has mediation really served its purpose? Well, it has. It has to an extent, because from 2009, it has really brought all the companies and the debtors to hold on to their feet on the ground and discuss properly the repayment schedules, not default and face this problem unless they don't have money. And three, there are still areas of, I would say, gray area still under IBC, which as a professional I'm facing, but that requires only working around IBC. But on an overall perspective, IBC is a regime which cannot be done away with in this country. Can an insolvency code and the mediation work together? We should find and try to marry in some locations, if possible, with regard to this. Thank you to everyone, and I think I can start taking, if at all there are any questions on this.
Thank you.
Either in the chat box.
Thank you very much.
Everyone wants a PPT more than the questions. I think I'll ensure that it's sent.
Yes, because it is very exhaustive and even I want it.
Thanks to my two colleagues. Thanks to my two colleagues who helped me. You know, normally it's like a senior counsel's job, do it alone. We do have good young.
You have an amazing set of boys. I know.
I need to give a credit to both of them.
Somebody's asking. Yeah, I know. Aravind, somebody's asking something.
Yeah,
Yes.
sir, I'm Nivedita Panda. I just want to know one thing. Actually, at the time of your presentation, you said that since the IBC code does not have any provision for any kind of mediation, the AA cannot go into it.
Yeah.
But if we look into the main intent or the object of the Mediation Act, it says that it can be, what I says, it can be invoked if there is any possibility for it. But it, as such, IBC code does not bar mediation by being suggested by a AA. That's what my view is. So I would like to have your further views on this subject, sir.
Yeah, I'm sorry to say that I may not be able to agree to what you're saying. But the purpose of the Mediation Act is completely different from the purpose of the Insolvency Code. Insolvency Code is maximization of value of assets to promote entrepreneurship. If under the word called promoting entrepreneurship or balancing the interests of all stakeholders, the context of that was not to find the person who's filing a petition to repay only his debt. You take a classic case. I don't want to, since I'm handling a case very controversial. The petition was admitted by NCLT. The largest financial creditor who would have constituted 100% of the COC was opposing the settlement. But because the operational creditor was supposed to be a very prominent institution, the NCLAT also anyway said there's no bar for us to record because both of them are settling. Settlement took place and they walked away. But 100 times of that amount, what they have paid the operational creditor is the dues to be given to the financial creditors. Can you say that they both had a mediation and they settled and walked away in that situation? So even if I agree with you that mediation can be used, in what cases it should be used also becomes an issue. Pre-admission. Post-admission, yes, because the numbers get crystallized, Is there a plan or not? And post admission also, in my view, it can only be in liquidation for the moment. Because in post admission also, if there's a rejection of claim, the COC will approve a plan or not. If the plan is approved, all OCs virtually are completely wiped off. It is only the FCs who get any money today. On a side track, I typically feel the time has come for giving the OCs also their due and bringing them back in getting some kind of money in the plan rather than writing off like this totally, which they won't get in liquidation, because of which so they're completely wiped out. Today, OCs are a irrelevant cattle class, if I may call them, insofar the code is concerned.
Correct, sir. Correct.
So it's a larger issue. We can debate it on a separate day, but today, for the moment, I think I should, with the greatest respect, you disagree that the intention of the code doesn't look at.
But sir, can't the resolution professional who is suggesting or who is trying to do a resolution plan get into mediation to make all the persons come to the platform and get into the resolution plan? Is it
That
not a feasible
If
way?
we presume, I'll put it this way, you find a proper solution between a person A and B as a resolution professional, and you recorded a settlement. Now, I am the same class of creditor, but I am a much more cantankerous client, and I don't like the settlement there. I want more. And then what I will do is these two colluded and got the money, and I'll take one more proceeding against you in IBBI. I don't think RP should expose themselves to this mediation at all, because it will be one more reason for pushing them again to IBBA proceedings, other things.
No. If the RP itself suggests COC to sit down and go into mediation and do it.
That's the committee suggestion. You're right. That's
Yeah.
to the extent the committee is suggesting.
Huh.
You consider 66% of the COC if they say that mediation is possible in this particular situation. Attended. So we had to wait and see. At the moment, no.
Okay. Okay, sir. Thank you, sir. Thanks a lot.
Thank you.
Sorry, nothing. No offense meant. Just that my suggestion.
Thank you. However, Aravind, my 2 cents is this lack of transparency, which we know, we both are practitioners. There is lack of transparency in the process, and that lack of transparency is due to stringent timelines. I'm sure you will agree there, and due to the accountability of everybody to different authorities. So to shock absorb that, at least somewhere in the interregnum period, if a gateway is provided to mediate, even under I don't know, as you said, section 7 looks a little tricky, and at least in a section 9 and a 10 applications, it may probably till that time the initial stage, what happens, the breaking of ice never happened. You're still hoping that everything is rosy and good. You're still trying. But when the reality hits you, at that point, if ventilation is given through this mediation by making some provision for it, it could help, is my feeling. Am I thinking? Maybe I am right or wrong. You are the better person to say.
I don't think so, even that. I beg to disagree. See, the Indian corporate law or corporate world, with the greatest of credit being given to them also to create the economic backbone of the country, they don't like a settlement unless it's the way they want. So the only way we lawyers also facilitate is we try to negotiate and not use the word prolong. We try to very a hard bargain. You're able to see me?
Yes. Yes.
Okay. So is my screen moving or?
No, you are very much visible and I can see your moment. You're all good.
So to put it in a nutshell, I don't want mediation at the moment to stop a CRP process. 9 out of 10 cases I am seeing promoters try to delay the process. If they couldn't get with the banker sorted out either in DRT or in their process in any other manner in the joint lenders, I'm talking about large ones. I'm not talking about small ones. That doesn't mean that you have to break away into 2 groups of 100 crores and above. The character and I would rather say the
behavior
is one and the same, irrespective of what the numbers are. So each one wants a settlement their own way. Okay, you file, it'll drag, it'll take 6 months, we'll use the time. So I may be pessimistic. I'm sorry to use it, I may be pessimistic. Parallel to that, the committee's recommendation is what I think, not that will work, we can try. Let the NCLT appoint a mediator. The petition has come in. Numbering will take some time. So the moment it's filed on the same day, they post it to a mediator and keep attempting. The paper processing will happen. The hearing will happen. It will all keep going on. If a mediation settlement happens, come and record it. If it doesn't happen, it proceeds. Can we consider this parallelly? If that is done, I think I should be the first votary to say we should try it. Particularly in OC matters first, operational creditor matters
Yeah,
first.
those matter.
Bankers matter, no, because by the time they go up their hierarchy and come back, they have their limitations, to be fair to them. But in a OC matter, it is the creditor who alone has to take a decision. If it's a large company, yes, they may have internal one, but they're still private more or less.
But
So
that is
yes,
yeah, that's what is happening. No, most of the things get withdrawn. Why are you filing a Section 9 so that you get at least half the money and you withdraw? That's the whole idea. So
see, therefore, recovery is not the whole process. So
Hmm.
if one person is withdrawing and walking away, it is going to have a whole impact on the remaining assets because it is a preferential transaction anyway if it goes into CRP. Again, the man who took the money has to come back and put the money back. So rather you don't pay the money to the single person, put the company into CRP. If you're a MSME, get the company out as MSME promoter itself, or if not, somebody else takes the company and goes, all these people go down the drain.
that is where I am asking you at that gesture where you don't have a control over taking it back even when the ICU patient comes back as somebody else's child, not as your child. So that gesture, if we can just intervene some mediation process.
I think we should only wait and see how the rules span and then implement it. I mean, the act, the way it has gone, it has been more predictable in my view. It's not been unpredictable at all. But now, with the 8 years of case law which has developed, there are people who manipulate the act very well to take over companies also. It's all going in a different way. So we have to wait and see how things will be if mediation as a concept is brought into the IBC process. I'm not saying in rules or amendment or whatever, as much as it's brought in. Say.
Thank you very much, Arvind, for your valuable time. I'll request Muthukrishnan sir to say a word of thanks because he's here today.
Thank you, Ambuli Madam. It's our senior advocate, Mr. Aravind Pandian, has dealt the subject in a grand manner. It's a very delicate subject, but he's in his own way dealt with pros and cons. What's going on? What are all the case laws? What is the subject as on date? He has excellently dealt with, and even a layman can understand in a grand manner. On behalf of the International Mediation Organization, I sincerely thank our friend, Senior Advocate Mr. Aravind Pandian for his valuable lecture done in this Sunday. I sincerely thank Madam Ambuli Menon, who has organized this in a grand manner. I thank all the participants. It's my duty to thank our President, IMO President, Mr. Sriram Segar, Auditor Arloli sir, Mr. Vijay Kumari Madam, Mrs. Kavida Madam, Mr. Sivakumar sir, Sankarvel sir, Srinivasan sir, Prem Rajakumari, and IMO Secretariat, who have done a very good work. I once again thank all the participants for participating in this function. We will be continuing the series of lectures. I request every one of you to join and enrich yourself this new subject. The SAR as Senior Advocate has explained the recommendations of the committee, which will go a long way to help the mediation in IPC disputes. I sincerely once again thank him for his valuable lecture. Thank you, thank you, thank you.
Thank you very much, sir. I'll message Ms. Menon. I'll just send the PowerPoint presentation to you now. You can just mail it to others.
Thank you very much, Arvind. Thank you very much again.
Thank you all. Thank you all.
Being a Sunday, thank you very much again.
Thank you. Thank you, Mr. Muthukrishnan. Thank you, sir. Thanks.